Catherine Amirfar.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
I'm here with Dame Rosalyn Higgins, former president of the International Court of Justice. Among the many prestigious appointments held by Dame Higgins, she's a member of the Institut du Droit International. She was appointed a Dame Commander of the Order of the British Empire in 1995 and was advanced to Dame Grand Cross in 2019. In 1988, she was appointed a Knight of the French Order of Academic Palms, and in 2007, she was awarded the Balzan Prize for International Law. Judge Higgins, it is such a pleasure to have you here, and I hope it doesn't embarrass you when I tell you that you're one of my personal heroes.
Well, thank you so much. I'm pleased to be with you.
Thank you. Now, your remarkable career in service to international law obviously spanned a very myriad roles, including, of course, your 14-year tenure on the International Court of Justice. Now, the court, of course, is a key component of the international system of peaceful dispute settlement. And if I could go very simple for a moment, it is, I think, not an overstatement to say that countries go to court to make the submissions as an alternative in many concrete ways to waging war. And that's part of the peaceful settlement of international disputes. Now, in your writings on and off the bench, you've talked a lot about the court and its role in the international system, including its obligation to develop principles of international law. Can you speak to that a bit and tell us what you think are the most critical points of development in your view?
Well, those are several big questions you've put into those introductory remarks. It is certainly true that some cases have come to the court where fighting was already occurring. I'm thinking of Cameroon against Nigeria. Significant loss of life had already occurred. In Qatar against Bahrain, we were told that if we didn't get it right, by which each side meant their answer, there would be fighting. And the court has played a real role in finding answers that, one way or another, the parties have lived with. And there has not been, for example, renewed fighting or fighting in the case of Qatar, Bahrain at all, in spite of the dire warnings. The court each time decided what it thought was correct on the basis of law. Now, on your development point, the answer has to be a little qualified. I think that the court is there to develop international law in the sense that first it should not turn away from cases because they are difficult. That is not the reason for finding there is no jurisdiction, however subconsciously, nor, I think, should it ever find a non-licet. There were considerable arguments about that in the nuclear weapons case, and very explicitly Judge Verschetin and I took different views. He thought the law had not yet decided these nuclear issues. I thought there was enough international law to be able to apply to this different issue. If you're always waiting for an answer on the very specific issue, you'll never decide anything. The law is there to apply to new problems. That's what we have to do. On the other hand, I don't think that the court is there to be a type of academia. I don't think we should be answering questions that are not put to us. So although I have great admiration for certain judges who over the years have written lengthy opinions on the totality of a topic that interests them, often in the human rights field, I don't think that's what you do as a judge. I think it's what you do as an academic. As a judge, the court must, as judges, the court must decide the questions that are put to it.
And that's a key distinction, I think, that you point out, the difference between the role of a judge and the role of an academic. And what in your mind is the downside of perhaps, as you put it, the more academic approach to decision making and going off on a very long discursive discussion of a particular area of law? What is the downside of judges doing that?
That it takes away the focus of what has been rigorously decided. Of course, one can disagree with that, and you can explain the grounds on which you disagree with the named points in the dispositive. But that doesn't require you to write 80 pages on the topic as a whole, regardless of the issues that were put to the court.
Understood. Obviously, you're off the court now, but what is, in your view, the key challenges for the court going forward?
Well, I think they are, in a way, continuing challenges. The court always has to deal with the reality that its clients are states. I think we've made a lot of progress about that in the last 15, 20 years. There was a period where, in my view, the court was overly differential to states, by which I mean that virtually anything that was asked for, extensions of time limits, declining to agree to set periods for putting in pleadings or for pleading orally, were readily agreed. Now, the court has become much more rigorous and has taken aboard the point that the big deference to the court is to states is that states will only be before the court by consent, no matter how removed that consent may be from the time in issue. But beyond that, it's a court of law, and it's for the court to decide, and that is a constant challenge. I think the court has also to remember to keep updated its practice directions. They were introduced during my time at the court to deal with issues that were difficult to deal with by changes to the rules. Though again, in that period, we started looking at the rules seriatim. Before, when the court had very little work, it could afford blanket revisions every so many years. But practice directions allow you to see what issues are arising in practice and ways to resolve those problems. They've been very well received, but I have noted that they've hardly been used in recent years, and it's if you don't use it, lose it.
No, absolutely. And what about it in your own home in terms of the conversation around Brexit? Do you think that reflects a larger theme, or is it really very, very focused on, obviously, the UK-EU relationship?
It is a UK madness at the moment. My husband just logged into BBC News, and we've heard that the third attempt of Theresa May has gone down. We have become so divided within our country. There is the feeling that we could have been helped along a bit by a more flexible EU. We haven't been, but the UK has great problems at the moment, not only with decision making, but with the tone of political discourse which has become so disagreeable.
Well, you're not alone, I have to say. As you've probably observed that we're having a similar phenomenon here in the United States, and I think we will see where that takes us. But history, we have to remember, has a lot to tell us about where we've been.
Of course, what I'd like to make clear is, and that perhaps is a difference from here in the US, the problems we're going through do not reflect adversely on the world of international law. There is, I think, the same courtesy and respect, not only in the courts, but in government as well, for
that's right.
for international law and international judgments. Happily, that's not changed.
Indeed, that is very true. So let's switch gears a bit to something I know that is near and dear to your heart, which is the immunity of international organizations. And obviously, you have done most recently the Oppenheim's International Law, United Nations, the 2-volume, and what everyone, the accolades you've gotten for it is a very comprehensive treatment on the legal practice of the UN. So, we had the privilege yesterday during the Hudson Medal Award to sit with Justice Breyer and hear some of his reflections on the United States legal fabric and the interpretation and role that international law has to play there. I wanted to talk to you a little bit about something that is very much in the headlines here in the United States, which is the U.S. Supreme Court's decision. And as you know, recently in a case, the U.S. Supreme Court took on the immunity of international organizations and really came to some conclusions about how that's analogous to foreign sovereign immunity in a majority decision. And Justice Breyer took it as an opportunity, citing one of your books, to take issue with that. And I wanted to open it up to you in terms of what you see that decision coming from in terms of the jurisprudence of the Supreme Court, and is it indicative to you of some forward trends either in the United States or internationally when it comes to organizational immunity?
Well, Justice Breyer was kind enough to cite some observations I'd made on international organizations not being the same animals as states, but in fact a wealth of detail on this topic is to be found in the 2 volumes on United Nations law. There are about 60 pages on immunities of international organizations. I think the arguments in this case are very finely balanced. I can't help but note that Justice Breyer was alone in his dissent. He normally has 2 or 3 liberal colleagues with him, so he was following a separate path, which is not, of course, at all to say that it's wrong. There were several issues that came together in a most fascinating way. I'll start with the purely temporal issue, because here at the heart of the case was the question of whether the phrase in the U.S. International Organization Act, the same as, referring to the immunities which an international organization would have, were to be the same as those accorded to foreign states, whether that meant that phrase was as it would have been understood in 1945 when your act was drawn up, or today where things, of course, on the state immunity side have changed and the immunities are narrowed. Just as I was going to the court, I gave a lecture which was then published in the International Comparative Law Quarterly, I suppose about 1996, called Time and the Law. And it tried to identify clusters of questions in which the answer would be decide by reference to as it was, and decide by reference to the change that have occurred, and to try to identify those. When I was a student, we were all told the Palmer's case, you decide by reference to the law as it was at a certain time. But I think by now we know that is so full of holes. There are so many circumstances in which that simply is incorrect, and the trick is finding out when. The majority of the Supreme Court decided, using as its guide the interpretive principles for understanding words that are recognized both in, I think, the common law and in international treaty law, that you look first at the plain words. And for the court, the same as clearly meant that if it had changed for the one, it had to change for the other, so that it retained the same as. Now, my mentor and teacher, the late great Myers McDougall, taught me at an early phase that words ain't what they seem. And even plain meaning, you won't know the plain meaning until you've looked at other things. To which, of course, the reply was always made, then the plain meaning has no meaning at all, because you're always looking at subsidiary methods. But I do rather incline to that point of view. For Justice Breyer, the temporal aspect was to be decided by reference, it's not correct to say not to plain meaning, but to rephrase it, the plain meaning of the words in the context of the temporal aspect could only be understood by realizing that states and international organizations are not the same. So for states, the reason for immunity is parem parem non habet imperium. No one state is superior in the law to another. Whereas for international organizations, the reason they have had through the years immunity was because of the functional necessity for that, in order to be able to carry out the functions that the states members who drew up their significant instruments desired they should do. So he urged that that is what we should all focus on. And in his view, that it remained necessary today, even when an organization is engaged in some commercial or trading measures, for them to have absolute immunity. Otherwise they would be exposed to a barrage of lawsuits.
And as you know, Justice Breyer really took the opportunities to say that the majority's decision portends a threat to multilateralism, in the sense of not appreciating, as you've just said, the key differences between international organizations and sovereigns. Do you agree with that?
I don't wholly agree with it, because what I've seen is that international organizations themselves know how to differentiate between their commercial activity and their, what I will call, public activity. Not, of course, sovereign activity, but public activity. I was counsel for the International Tin Council in those years of litigation in the British courts when this subsidiary body of the United Nations went catastrophically bankrupt, leaving third parties in a parlous state. And the International Tin Council was not immune so far as its trading was concerned, because it had said so. That was in its constituent instrument. It was doing some other things besides stabilization, mostly, of tin prices. That one can readily see as a public function. It wasn't for its trading benefit. And there are many examples of international organizations knowing when to say, for this activity, we shall not be immune. Now, in the case of the IFC, what it was doing, supporting in funding private sector entities compared with the World Bank, which helps the public sector entities, one can see it looks a little more on the commercial side. It does not have that statement that for some of its activities it is not immune, but there has been a history of waiver when it's not felt it needed an immunity to perform its functions. And it also has mechanisms for helping third parties who are hit by what it has done but may not be able to get recourse in the courts. So I think it is all a little more qualified than was suggested in the Supreme Court.
Indeed.
And the dissent.
So perhaps a note of optimism in all of this.
I think that perhaps it is not necessary to, on the temporal point, interpret by reference to years ago, which does go against the grain, in order to maintain the effective functioning. There have been in practice developed these other ways of waiver and side arrangements and so forth. So I'm optimistic the floodgates won't open. And there's this very interesting passage of Judge Breyer where he says the parties must have known back in 1946 that it would be necessary through time for absolute immunity to be sustained, at least for international organizations. And it reminded me of a passage we have in the Iron Rhine case. That was an arbitration, not an international court case, an arbitration between Germany and Holland, and I presided in that case. And it's fascinating to put those two passages side by side. We said, back in whatever year the relevant instrument was, they must have foreseen there'd be changes through the years.
That's right.
And when the crunch came, it would have to be decided by reference to the developments that had occurred.
So the echoes.
Echoes, but in the opposite direction.
Indeed. Well, thank you so much. As usual, a privilege and a pleasure. Is there anything else you'd want our listeners to hear?
No, but do all try and follow what the American Society is doing and become members if you can, because there's something there for everyone, whatever their level of knowledge and interest in international law.
Thank you so much.